Hey besties! Wayfarer Studios and the New York Times are officially going head-to-head in court, and things just got very messy, because now it's starting to look like Blake Lively might not have the backup everyone thought she did. Here's what's going on. Wayfarer asked the court to pause the case, specifically the fight over attorney's fees under anti-SLAPP. But the New York Times came back swinging. They're not just opposing the delay, they're calling it out. And in doing so, they dropped a subtle but very telling point. They essentially admitted that Wayfarer may actually have a strong argument against Blake Lively in federal court. Why? Because federal court might not even be the right place for her to request those fees in the first place. And here's the twist. The Times says that's exactly why they chose to file in New York State Court instead. So yes, that's some indirect shade right there. But it doesn't stop there. The Times is asking the judge to deny the delay completely, move forward with summary judgment, and award them roughly $181,000 in legal fees. Now let's break down their core argument in simple terms. They're saying Wayfarer isn't actually fighting the legal issues. They're stalling. Instead of responding directly, Wayfarer is asking the court to hit pause based on a hypothetical appeal that hasn't even been filed yet. And the Times response? That's not how this works. A stay isn't automatic, it's rare, and you have to justify it. According to them, Wayfarer hasn't. In fact, they argue that delaying the case would unfairly hurt them because it blocks them from recovering legal costs while waiting on an appeal that may never even happen. And even if it does happen, the Times says it won't change the outcome anyway. They're basically calling the original dismissal an easy win. So in their view, this request to pause everything, just a delay tactic. Now, here's where it gets more complicated. In federal court, the judge has already said Wayfarer can't appeal yet, not until all attorney's fee issues are resolved. Why? Judicial efficiency. The court wants everything handled and appealed at once, not piece by piece. But here's the problem for Wayfarer. The Times filed this case in state court on purpose because Wayfarer itself argued that federal court is the wrong place for anti-SLAPP claims. So now the Times is flipping that argument right back on them. You can't say federal court is the wrong forum and then turn around and use that same federal process to delay a case happening somewhere else. You can't have it both ways. They also point out something else. Wayfarer hasn't tried to pause the other fee battles, including the ones involving Blake Lively, which makes their strategy look selective. According to the Times, it looks like Wayfarer is slowing down the cases where it's weaker and pushing forward where it thinks it can win, and the court shouldn't reward that. Now, stepping back, the bigger issue here is anti-SLAPP law. In New York federal court, judges are often hesitant to apply anti-SLAPP protections because there's no federal version of that law. So instead, cases get dismissed on other grounds. And that's exactly what happened here, not anti-SLAPP. But Wayfarer is pushing back hard. They argued the judge overstepped, relying on an unpublished case and considering facts that shouldn't have been part of the decision yet, because at the motion to dismiss stage, the court is supposed to assume the claims are true, not weigh them against outside arguments. And according to Wayfarer, that line may have been crossed. So now, everything comes down to the judge in New York. Do they allow the delay or move forward and potentially award those fees to the Times? Either way, this legal fight is far from over. I'm going to be honest with you guys. I really don't know how this is going to go, and I don't want to give any false hope that this will work out in Wayfarer's favor, because it very well could go the other way. New York courts generally do not like granting stays based on hypothetical appeals, and this case is in state court, which is actually the proper place for an anti-SLAPP claim, since it's grounded in state law. I've gone through the Wayfarer brief, we even discussed it when it was first filed, and even now it's still unclear how the judge is going to rule. New York's anti-SLAPP law is extremely strong, both in how it's applied and in the protections it gives to defendants. And there's another important factor here. These cases are meant to move quickly. Anti-SLAPP laws are designed to prevent prolonged litigation because of the harm it can cause. So granting a delay could go directly against the purpose of the law itself. That said, it's not the best look that Wayfarer didn't directly respond to the summary judgment arguments. Now, to be fair, they did submit the full federal court order, so the New York judge can review everything and decide whether anti-SLAPP even applies here in the first place. Because to win under anti-SLAPP, you have to show two things: that the case involves public participation or petition, and that it was brought without a substantial basis in fact or law. The New York Times is arguing that the dismissal alone proves the claims had no real basis. But Wayfarer's position is different. Losing a case doesn't automatically mean it was frivolous. It takes more than just failing to state a claim. And that distinction matters, because the federal judge never said the claims were frivolous or baseless. The dismissal was based on privilege. In other words, even if everything alleged were true, it would still be protected under reporter's privilege, shield laws, and litigation privilege. So the court didn't actually rule on whether the claims themselves had merit. But the Times is trying to frame it that way. They're also emphasizing that their role in this entire situation was relatively small, and honestly, that's a fair point. Compared to the broader dispute between Blake Lively and Wayfarer Studios, their involvement is much more limited. Yes, they worked with Lively on publishing the article, and there's been a lot of criticism about how that was handled. But at the end of the day, the press is given a lot of protection. Courts, especially in New York, tend to strongly protect media organizations like the New York Times, and that makes cases like this incredibly difficult to win. I've said it from the start, going up against the Times is an uphill battle. They rarely lose, and even when someone wins an appeal, the outcome often doesn't change. Just look at Sarah Palin. She got a new trial and still ultimately lost because she couldn't prove actual malice. And that's the key issue here. Malice doesn't mean dislike, it means reckless disregard for the truth, publishing something without verifying it, or ignoring facts that contradict it. And proving that, it's extremely difficult. Even if this gets appealed, another judge could very easily come to the same conclusion, that the reporting is protected. Now, what makes this case especially complicated is that it involves reporting on a document that wasn't even filed in court, labeling it as a legal complaint, and then extending reporters' privilege to that situation, which isn't always standard. That's part of what makes this so unusual. But overall, I just don't see a New York judge being easily persuaded to grant a stay here. What Wayfarer did do, though, is make sure everything is on the record. So even without directly opposing the summary judgment, the judge still has to independently evaluate whether it should be granted. That means reviewing the federal ruling and asking, was this case dismissed because it had no basis in fact or law, or was it dismissed for legal protections like privilege? The judge doesn't have to simply accept how the Times is framing it. And while that federal decision is extensive, only a small portion actually deals with the Times. What's really interesting, though, is that the Times seems to acknowledge that Wayfarer may have stronger arguments in federal court, especially when it comes to attorney's fees. They even admit they avoided filing there for that exact reason. So, in a way, they're conceding that point. They're also not saying the claims against Blake Lively or others are meritless, only the claims against them. They describe this as a complex, multi-party dispute and emphasize that their role was minimal, and that's clearly the strategy now. They're distancing themselves. They're essentially saying, this is a dispute between Blake Lively and Wayfarer Studios. We're not the main players here. We were just reporting on matters of public concern, and because of that, they believe they should be awarded legal fees. At the end of the day, I don't think a stay is likely. It's just not something New York courts typically grant, especially not based on a hypothetical appeal. Wayfarer took a risk by not directly fighting the summary judgment and instead asking for a delay, and that does leave them in a more vulnerable position. But even if they lose, it doesn't automatically mean the full $181,000 will be awarded. The court could reduce it, award partial fees, or deny fees altogether. There's still a wide range of possible outcomes here, but one thing is very clear. The New York Times is no longer positioning itself as aligned with Blake Lively. They're stepping back and saying, this isn't about us. This is between Blake and Wayfarer, and we just want out. So what do you think? Does the judge grant the stay, or move forward and potentially award those fees? And what do you make of the Times distancing themselves like this? Drop your thoughts in the comments below. And don't forget to like, subscribe, and hit the bell so you never miss an update. Thanks for watching. Bye, bestie.